In this webinar, I'm going to talk to you about the legal ombudsman process. Maybe you haven't had experience of our service yet, or maybe you are aware of a complaint that's coming our way and you want to understand a little more about how we will approach it. Before explaining our process in detail, it's important to note that our values are at the heart of the work that we do. Our role is to work in an open, fair, independent and effective way. We are an independent ombudsman scheme that resolves complaints about legal service providers in a fair and effective way. We don't take sides or make assumptions about who might be right or wrong. When it comes to individual legal complaints, our role is to listen to both sides, consider the evidence from both sides, and make an independent and fair determination about the service that's being provided. We're open with both complainants and service providers when it comes to what we can and cannot do. In addition to this, we're decisive when tackling complex issues. Our purpose is to resolve complaints impartially, promote service excellence, and be a champion of best practice. We see a lot of misconceptions about who we are and what we do, both from service providers and consumers. We're not on the side of complainants, nor are we here to chastise lawyers. But when we can see data and trends emerging from our investigations, we will use this to feedback and help inform the profession. This helps us and others to shape what best practice looks like in relation to complaints. When a complaint is brought to our attention, it's first dealt with by our general inquiries team. Complaints may come by email, by phone, or by a form on our website. The general inquiries team will do some initial checks before passing it to an investigator who will undertake a more thorough assessment of the case. The things that they look at will include: is the person being complained about an authorised person as set out in the Legal Services Act 2007 and our scheme rules? If they're not, the complaint would fall outside of our jurisdiction. Has the person who's complaining received a service, or were they unreasonably refused a service? If the answer is no here, it's unlikely the complaint would be within jurisdiction, although there are some exceptions, such as beneficiaries to an estate. Has a complaint been made? If it hasn't, the complaint is likely to be premature, and we will explain to the complainant that they initially need to make a complaint to their service provider, allowing them 8 weeks to respond. If the matter remains unresolved after this time, they can then return to us with their complaint. We will also be looking to see whether the complaint falls within our time limits, allowing us to investigate. You'll find more details about our time limits on our website and in the scheme rules. But in summary, the act or omission being complained about needs to have happened within the past year. If it happened further back than that, then the complainant's date of awareness of the act or omission needs to be within the past year. At this assessment stage, we will also consider whether the legal ombudsman is best placed to investigate the complaint raised. There may be reasons why we're not. For example, it may be an issue that's better dealt with by a court, or we may determine that the service provider has already offered a reasonable remedy and that remedy is still open for acceptance. Once we've decided a complaint is suitable for investigation, the process begins to determine whether or not the service was reasonable. The starting point for any investigation will be the investigator taking time to ensure that they've fully understood the complaint being raised. They'll usually speak to the complainant and to the service provider to understand how the complaint came about, why it hasn't resolved, and also to talk through their expectations of the parties to the complaint. The investigator will then be in a position to decide what evidence they need to see. They will ask both the complainant and the service provider to give them information and evidence, and once this is received, they'll undertake a review. Once this review of the evidence has been completed, the investigator will discuss their findings with the aim of helping the complainant and service provider reach an agreed outcome. It may be that there are other opportunities to resolve the complaint during the course of the investigation, and an investigator will always keep that in mind. Ultimately, we aim to resolve complaints quickly and simply where possible. We appreciate, however, that we won't be able to reach an agreed outcome on every case. For complaints brought to the Legal Ombudsman before the 1st of April 2023, where an agreed outcome has not been reached, the investigator will share with the parties a case decision and invite the parties to comment on this. If the parties agree with the investigator's findings, the matter is treated as resolved. If either party rejects the findings of the case decision, the case is passed to an ombudsman who will take these comments into account, along with the case decision and the evidence received from the parties during the investigation when making their final decision. If the Ombudsman's final decision is accepted by the complainant, the final decision is binding and enforceable. For complaints brought to the Legal Ombudsman on or after the 1st of April 2023, where an agreed outcome has not been reached, the investigator will share with both parties the findings of the investigation with a time limit for response. If any party indicates disagreement within that time limit, the investigator will arrange for an ombudsman to issue a final decision, but only in circumstances where the disagreement is either based on new facts or evidence which may have a bearing on the investigator's findings, or on the basis of a challenge to the facts or evidence which the investigator's findings rely upon, or in the circumstances where the Ombudsman determines it's fair and reasonable to issue a final decision. The Ombudsman will take the parties' comments into account when making a final decision, along with the case decision and the evidence. If accepted by the complainant, our final decisions are binding and enforceable. Another issue I wanted to cover in this webinar is case fees. I am aware the £400 case fee is often an issue of concern for service providers, so I felt it was important that I touched upon this. Many service providers think case fees are always charged, and this is partly correct. They are always chargeable, but not always charged. 55% of cases last year had the case fee waived. Basically, once a case is accepted for investigation, the case fee is chargeable. This is set out in the Act. However, there are circumstances where we can and do waive it. It's not discretionary, it's rule-based. It's a two-stage test. Firstly, was the complaint abandoned, withdrawn, or resolved in your favour? So, if it's abandoned or withdrawn before we reach an outcome, the test is passed. Likewise, if we reach an outcome and we say your service was reasonable, that's in your favour. The test is passed. What a lot of people don't realise is, if we find poor service and we direct a remedy, let's say £200 for example, but you already acknowledged poor service in your first tier response and already offered the same or more, that is also in your favour. Because what you offered was appropriate to fix the problem at first tier, and therefore we've not directed anything additional. That counts as resolved in your favour, and you would also pass the test. The second part of the test, and you must pass both parts of the test to have the case fee waived, is whether your complaints handling was reasonable. So if we investigate and find no poor service and direct no remedy, it's resolved in your favour. But if you didn't respond to the complaint, you'll not pass the second part of the test, and you therefore need to pay the case fee. We have developed guidance for the profession on good complaint handling and also how to decide an appropriate remedy. By considering these bits of guidance, you are in a much better position for us to consider waiving the case fee. Thank you for watching this webinar. Please see our other webinars for information about how to prevent complaints, good complaint handling, and how we determine complaints. Thank you.